Hello all, welcome to Dr. Rajkumar IAS KS Academy. Hope all of you have done this prelims well. And with regard to polity questions in this prelims 2025, how they have put the questions, how many number of questions have come, and what is the percentage of questions that we find in this 100 questions lot, and the answer key is what we are going to discuss now. See, we have taken 15 questions which are related to constitution and polity. So almost 15% as usual they have asked from polity. With regard to the toughness of polity questions, I will say more or less they are easy. Here and there little bit of thought process is required, and one or two little you can call intermediate level of toughness. I won't call any question here to be very tough. And few questions which appear to be tough also, which we will be seeing, it's actually not tough. We could easily manage that with good amount of wise calculations. So that is how the questions are made. So here if you find out, let us get into the questions actually. So this question you take. The most important thing with regard to these questions is that the very important thing is first we have to make sure that which are not correct, that needs to be brought. So which are not correct. Okay, so this question says which of the statements given above are not correct. So this is the prime area that we have to understand first. So here if you see panchayats at the intermediate level exist in all states. See, those states which have a population of less than 20 lakh need not have panchayat at intermediate level. So absolutely this is a wrong one. Similarly, if you see, to be eligible to be a member of panchayat at the intermediate level, a person should attain the age of 30 years. Such a thing is not there. Panchayat as such, the age limit is anyone who is 21 and above can very well be a member. Then a chief minister of a state constitute a commission, though this is also wrong. Chief minister of a state constitute a commission to review the financial position of panchayats at the intermediate level and to make recommendations regarding the distribution of the net proceeds of taxes. And see, while studying itself we can easily get to know. Under Article 243 all this three comes straight to straight. And if you see the Finance Commission, State Finance Commission appointed by Governor, which does this job and not Chief Minister. So in this case if you see all these three are not correct, and so D is the answer. Yeah. Now we can see the second question. The power actually of the questions, this question has little more intermediate level of toughness, we can say, that too not very tough and all. So if you see here, the power of Lokpal applies to public servants of India. Here it is correct, which are all correct. Public servants of India, but not to Indian public servants posted outside. See, that not to is not right. It is also applicable to Indian public servants posted outside. So this is not right. The chairperson or a member shall not be a member of parliament or a member of state legislature or union territory, and only the Chief Justice of India, whether incumbent or retired, has to be the chairperson. Here any other eminent person can also be there. Yes, this is correct. Chairperson or a retired CJI or a retired CJI can be there. It also applies to anyone who is an eminent person, who meets the eligible criteria. So this statement is also wrong. Second one, the chairperson or a member shall not be a person of less than 45 years of age. The chairperson or a member shall not be a person less than 45 years of age on the date of assuming office as the chairperson or a member, as the case may be. And this is correct. If you see, these are wrong. This is a correct statement. And here if you see, almost here itself we actually arrive at answer. The Lokpal cannot inquire into allegations of corruptions against sitting Prime Minister. This is one question, though it is little twisty, but arriving at this answer, we could have arrived at the answer. Because 2 is wrong. When 2 is wrong, absolutely this goes off actually. And 1 is wrong, this goes off actually. Obviously 3 is correct, so this goes off actually. Then what is left is coming there itself. This is one question where we find elimination. So Lokpal cannot inquire into allegations of corruption of the sitting Prime Minister. No, it is even, there are certain conditions for it, but it is allowed. So 3 is this one, and so A is the answer here. Fine. So consider the following statement with regard to pardoning power of President. See here correct. The exercise of this power by the President can be subjected to limited judicial review. Can pardoning power of the President be subjected to judicial review? See here, the pardoning power of President is not his absolute right. The pardoning power of President is constitution given right, but he can exercise it on the recommendation of the Council of Ministers headed by PM. And again, if such a pardon is done with an ulterior motive, the Supreme Court in numerous cases has said it can be judicially reviewed. The intention of the pardon can be judicially reviewed. Clemency can be judicially reviewed. So a limited, this one is allowed. Generally, for each and every clemency, you can't go to court. Other than that, yes, it is allowed. The President can exercise this power without the advice of central government. No, he cannot exercise this power without the advice of government. A is the answer for this. Okay. Then, on the dissolution of the House of People, the Speaker shall not vacate her office until immediately before the first meeting of the House of People after the dissolution. So, this is often asked question in UPSC. Before this also many times, not more than once, many in the sense more than once in UPSC they have asked this statement. So on the dissolution of the House of People, that is Lok Sabha being dissolved, the Speaker shall not vacate his office immediately before the first meeting of the House of the People after the dissolution. Absolutely correct. According to, so correct we have to find, according to the provisions of the Constitution of India, a member of the House of the People on being elected as Speaker shall resign from his or political party immediately. According to the provision of the Constitution, a member of the House of People on being elected as Speaker shall resign from his political party. Such a provision is not there in the Constitution. We all will be happy if such a position is there, provision is there, but it is not there. It was only President Neelam Sanjeev Reddy, he was president also later. When he was speaker, he resigned from the post of a party and he became so. So this is a wrong statement. So 1 is right, 2 is wrong, 2 should not be there. 2 should not be there. The speaker of the, okay, 2 should not be there. When 2 should not be there, you yourself can understand. Answer is arrived. The Speaker of the House of the People may be removed by his or office by a resolution of the House of People passed by a majority of the then members. Whenever we see then members, it means effective or absolute majority. Effective or absolute majority. So the answer is arrived. C is the answer. We have arrived at the answer. Even prior to the answer, we have arrived at the answer when we found 2 to be wrong. So again I say, elimination technique, 1 or 2 questions, it has worked. But that doesn't mean that we have to believe in it. That and all will not, that like pre-2023, that situation is not there. Then if any question arises as to whether a member of the House of the People have become subject to disqualification under 10th schedule, President's decision in accordance with the opinion of the Council of Ministers shall be final. Article 103's statement is this, but not for 10th schedule. For 10th schedule, it is the Speaker. It is the Speaker. So it is absolutely not right. There is no mention of the word political party in the Constitution. 10th schedule mentions it. 10th schedule mentions it. Answer is D, straight. There is a word. 2/3 of the members of a political party in representatives of a political party in assembly splinter away. Then this is applicable. This In India, the state governments have no power for making rules for grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territories. Actually, the state governments have no power. See here, with regard to minerals, mines and minerals, it is both in union list and both in state list also. In state list, what they say, there's for regulating of the minerals and the mines in the state, they can very well frame rules and they can regulate it, and for this mining of mines, for regulation of mines, provided which is consistent with the list one. Consistent with the union list, what it says on mines, that's all. So the statement is wrong. It has power. It has power. Then in India, the central government has the power to notify minor minerals under the relevant law. Yes, this statement is right. This statement is right. So in this, if you see here, statement 1 is not correct and statement 2 is correct. Okay, statement 1 is not correct and statement 2 is correct. Okay, fine. Let us see the next one. So, with reference to Indian polity, consider the following statements. If you see here, above are correct. An ordinance can amend by central act. See, as normal, an ordinance can do whatever the parliament has the power to do. Can a parliament amend any central act? Yes, it can. So accordingly, an ordinance can amend a central act. An ordinance can abridge fundamental right. This is right. Absolutely wrong. 2 is absolutely wrong. Already I arrived at the answer. Okay, an ordinance can come into effect by a back date. That means retrospective. See, normally whichever law made by parliament, a civil legislation can have retrospective effect. Criminal legislation cannot have retrospective effect. Accordingly, this is correct. Even before that, we have arrived at the answer. So, but anyway, C is the answer here. So, 8. With reference to India, consider the following statement, pretty straight. As per the provisions of the constitution. So indirectly they are asking which are constitutional bodies. Okay, Interstate Council, Article 263. National Security Council, no, it is again, this is statutory, this is executive order. In late 90s, they brought it under an executive order, and zonal councils, 7th Amendment Act 1956, through that the State Reorganization Act brought zonal councils. So only one. A is the answer here. Consider the following statement regarding constitutional provisions in India. The Constitution of India explicitly mentions situations where governor of a state can act in his or her discretion. Article 163, clause 2 explicitly says that there is discretion for governor, which president also, that explicit statement not there. Apart from that, in Article 371, there are numerous articles, be it in Nagaland 371A, be it in Arunachal Pradesh, all these places if you see, the governor has got discretionary powers. In Arunachal Pradesh, to maintain law and order, governor has discretionary powers. So, he mentions situations where governor, yes, it is correct statement. The President of India on his or own reserve a bill passed by a state legislature for consideration, even without it being forwarded by the governor, it is not right. There is no provision as such. And there is no convention, there is no provision as such. Only A is the answer for this. Now, again, this is a pretty straight one. If you see correctly matched, separation of judiciary from Article 50 DPSP. Judiciary from executive. Valuing and preserving the rich heritage of our composite culture. 51A. Okay, that is there. Then prohibition of employment of children below the Article 24. Article 24, again that is there. So these are all pretty straight. So which are correctly matched, if they say all the three are correctly matched, such a easy question. Consider the following statement regarding scheduled areas. See, frequently in past 1 decade alone, at least 3 to 4 times they have asked questions on scheduled areas. And not more than 4, I suppose. Nowadays it is coming more. So I will not be surprised if they go a little deep in these questions also in coming years, in scheduled areas. So here, following statement, scheduled areas under the 5th schedule of the Indian Constitution, if an area in a state is declared a scheduled area under the 5th schedule, if an area is declared a scheduled area under 5th schedule, the state government loses its executive power and the local body assumes total administration of such area. It doesn't lose and all its executive power. Through governor, it can exercise its power. Local authority gains little more power, but it doesn't lose and all power. Okay, so that is not right. The union government can take over total administration of such areas under certain circumstances on the recommendation of the governor. See, union government doesn't take over such administration. Governor again can give advice on 5th schedule how to run. The union government taking over such a thing, such a provision is not there in the 5th schedule. So D, neither of it is there. D is that. It was also pretty straight. Even that question, I say, through wisdom we could have answered. If we could have thought little more into it, even if we are not so specific in that question. How can union government take over a local authority as such? Even state taking over, it is 356, but not for union, this scheduled areas and all, such a provision not there. Yes, governor's control or governor's little discretionary power is little there, but that doesn't mean that taking over the administration and all. Then, subject to the condition for a constitutional amendment with respect to which of the above, ratification by legislatures of not less than 1/2 of the states is required in this bill. See, Article 368, Clause 2. In the 2 also, the part that starts with provided that following A, B, C, D, E, 5 items would be there. So union list 7th schedule where center state is involved. Yes, you need this provision. Then extent of executive power. Yes, Article 153. Yes, you need this provision. Conditions of governor's office. Article 158. Conditions at governor office to amend and all. You don't need the states and all to be involved. 3 is not there. So 3 should not be there, and 1 is anyway the answer. 3 is absolutely not there. Okay, with reference to Indian polity, consider the following statements. The governor is not answerable to any court for the exercise and performance of the powers and duties of his office. Article 361. Straight. Correct. No criminal proceeding shall be instituted or continued against the governor. Straight. Civil proceeding, 2 months notice. Criminal proceeding, nothing. Straight. Correct. Members of the state legislature are not liable to any proceeding in any court in respect of anything said or any vote given in the legislature or its committee. Members of state, Article 194, straight to straight. D, answer. Now, you see here, this is a GK kind. You can call it polity, you can call it GK related polity, anyway. So how many of the above pairs are correctly matched? You see here, Arunachal Pradesh, named after a fort, the state has to, and Mauling and Namdapa, it has got. That way also you can analyze. Yes, Itanahar is a name of a fort, correct only. The state came into existence, 13th Amendment Act 1962. Okay, it came into existence, right only. And initially a part C, a state, it became a centrally administered territory, and it was initially a part C state and later attained full statehood. That is also again correct with regard to this. So 3, all the 3 are correct here. Then 15th one, the National Automotive Board. You take this this question. You are not knowing much. I am not sure if at all we are thinking like that. Even with wisdom, that is what we can answer this question to. So National Automotive Board, correctly matched they are asking. See, National Automotive Board, why will it be in commerce unless they themselves have given other IAS? So okay, Choir Board, you take it. Choir Board, obviously it has to be here only. National Center for Trade Information, trade when we say commerce. Automotive Board, heavy industry. So here it is everything almost matches. perfectly. So imperfectly, matches imperfectly, not perfectly. So here what should be the answer? Correctly matched, none. D is the answer here. Okay. So with this, what we get to know about this exam, this time 15 questions we saw. I will certainly call making mistake in polity could not be a question. You could have easily attempted these 15 questions. Here and there, silly mistakes, you could have left one or two. Lokpal related question, little twisty, but there also they were kind enough to give an option elimination technique. So that way, I will say polity cannot be a hindrance for you with regard to being, with regard to getting qualified or not. Okay. Thank you. All the best for all.